Tom, looks like you're ready. Michelle, you're ready? Okay. Welcome, everyone. I'm John Baza, the Director of the Utah Division of Oil, Gas, and Mining. It's 10 o'clock, or a little after, on November 9th, 2017. And this is an informal hearing to receive comments. This is an informal hearing to receive comments on the Division's tentative approval of Kilgore Companies, LLC's application for an amended Notice of Intention to commence large mining operations, or NOI. Once the Division receives a tentative decision on an application to amend an NOI, the Division gives notice to the public and provides a deadline for public comment. If the Division receives any written objections of substance during the public comment period, it must hold an informal hearing where it can accept comments from the parties and members of the public. These informal hearings are governed by Utah Administrative Code Rule 647-5-106, and I would refer you to that rule for any questions on procedure today. You'll notice that we've arranged for a court reporter to transcribe this hearing. I would ask that to allow the court reporter to properly capture the comments made today, we avoid having more than one person speak at a time, and that you properly identify yourself for the record when it's your turn to speak. Seated next to me is Emma Whitaker. She is an attorney from the Attorney General's office, and she is going to be my counsel today as we work our way through this hearing. Now I'll provide a brief background on how we got here today. On March 30th of 2016, Kilgore filed an application for an amendment to its NOI, and the Division tentatively approved the amended NOI on August 14, 2017. On September 5th of 2017, the Division began receiving public comment, and several Benjamin community members requested a hearing. After receiving the community members' comments, the Division scheduled this informal hearing to give the parties and the public an opportunity to provide comments on the tentative approval. Before we begin, I want to briefly address the South Utah County Community Voices request to postpone the hearing and relocate the hearing to a venue closer to the Benjamin community. The Division and I thoroughly explored options for postponing and or relocating the hearing and found that there were limitations. Notice of the hearing had already been submitted to a local newspaper, and we were unable to find an appropriate venue near Benjamin. And especially with the production equipment that we have here, we found that it was more amenable to have this hearing at this location. I also want to reiterate that this hearing is not the community's last chance to be heard. If members of the community are dissatisfied with the results of this hearing, those parties may file an appeal before the Board of Oil, Gas, and Mining. I'm sensitive to the fact that some interested community members cannot attend today. However, we are both live streaming and recording the proceeding today, and these items are available to view on the Utah Department of Natural Resources YouTube channel. So if you go to YouTube and search on the Department of Natural Resources, you should be able to find this hearing there. I expect that each of the parties received the letter outlining the procedures and scope of the hearing for today. I'd like the parties to keep that letter in mind when providing comments. For the benefit of everyone in attendance today, I'll briefly summarize the contents of that letter, which relate to two things: the procedures that will follow today and the scope of the hearing. With respect to the procedures during the hearing, the Division, the group of community members, and Kilgore, seated at the three tables, will each have 20 minutes to comment on the Division's tentative approval. We'll start with the Division, then turn to the community members, and finally to Kilgore. To ensure an efficient hearing, there will be no direct cross-examination of witnesses, and I will not permit arguments back and forth between the parties. Once each of the parties has presented its comments, I'll give each party a rebuttal period of 5 minutes to make any final points or respond to anything said in the previous comments. After the parties have presented, I will open the floor to public comment. Each commenter will have 2 minutes, and I would ask you to come to the podium with the microphone to make those comments, and you'll see a 2-minute public timer as we keep track of those comments. If you plan on making a comment during the public comment period and have not done so already, I'd ask you to please sign up on the sheet at the door, or as you come up and make comments, there's also a sign-up sheet at the podium. After this informal hearing concludes, an additional period for public comment will stay open for 5 days until close of business on November 14th, 2017. If anyone wishes to submit a written comment in paper format in that time frame, please send it to my attention at the Division of Oil, Gas, and Mining, 1594 West North Temple, Suite 1210 in Salt Lake City, Utah, zip code 84116. Or you may also email an electronic comment to the following email address, and you may want to write this down. It is ogmminerals, one word, at utah.gov. Again, OGM as in oil, gas, and mining, minerals at utah.gov. This leads me to the second point addressed in the letter, scope of the hearing. Purpose of this hearing is to receive comments on the Division's tentative approval of the amended NOI. Therefore, please limit your comments to matters relating to the amendment. This is not an opportunity to express comments about other portions of the permit that have already been permitted historically. This is an opportunity for interested parties to point out where the Division may have missed something in their review and where the permit does not meet the pertinent statutes and rules. And I refer to the statutes and rules affecting the Division of Oil, Gas, and Mining. There are certainly areas of mining industrial development that the Division lacks jurisdiction, that are under control of other entities of state government. And this is probably not the time to be addressing those comments, as those other entities will have their responsibility to approve actions under their rules. Any comments that do not fall within the scope of this hearing hinder the purpose of the hearing itself, and the Division will not be required to consider those comments. Having said that, I will say that as a hearing officer, I'm going to give substantial latitude to talk about things that you have on your mind. But again, let's try to keep it within the scope of what we're trying to do today. With that, I think it's appropriate to begin. And I would ask the attorneys for parties or the public members who are representing the community to please identify themselves for the record. And let's start with the Division.
Thank you, Mr. Baza, and thank you to members of the public and to Kilgore for being here today. My name is Meg Osswald. I am an Assistant Attorney General from the Attorney General's Office, and I am representing the Division of Oil, Gas, and Mining today.
For Kilgore.
Good morning, Mr. Baza. Graydon Jackson on behalf of Kilgore Companies. I'm joined by Stuart Lamb and Joe Johnson, who will also be presenting today.
And for the community.
Good morning. We're glad to be here today. We appreciate this opportunity to express our thoughts and our concerns. My name is Julie Sainsbury. I am on the board of the South Utah County Community Voice, and I'm here representing their membership, also here representing community members in our area.
Thank you very much. Thanks to all, and especially for those people who have driven some distance to get here today. So let's turn the time over to the Division, and we'll start the Division's presentation. Then we'll go to the community, and then we'll go to Kilgore.
Thank you. And on behalf of my client, We're thankful for the thoughtful public comment that was submitted and for the opportunity to discuss this permit with members of the public and with the operator today. Due to the informal nature of this proceeding, I'm going to let the division do the vast majority of the talking. First, I have Paul Baker. He will provide an overview of the current mine plan and the proposed expansion. Next, April Abadi will provide more detail with respect to the specific public comments we received and how the mine plan and expansion attempts to address those and complies with the related rules. I also have with me Associate Director Dana Dean, and she'll be available to provide more information or answer any questions that may come up on a rebuttal. With that, Mr. Baker, go ahead.
Thank you. My name is Paul Baker. I'm manager of the Minerals Regulatory Program. And so I'm going to present just an overview of the current mine, permitted mine, and the proposal as we have it. And I plan to use the cursor to point to some things on maps that I have here. First of all, a general location map. The mine, as it exists and is proposed, is in southern Utah County, and it's not too far from Utah Lake. It's basically directly west of Spanish Fork. And outlined in blue here is the area that's currently permitted. And again, an aerial view of that area. And let's see, where's my cursor? Oh, there it is. Okay. And just for reference, this area along here is the Highline Canal. And this is a map from the current plan. I use the terms notice, NOI, plan pretty much synonymously. So this is the area that's currently permitted. And again, where's my cursor? Well, the area near the center, the oval area, is basically the crusher and asphalt plant. Just to the east of that is a stockpile area. Around the perimeter, there are topsoil piles. The mining area is pretty much on the west side, and then there are some roads and parking areas on the east and on the north. This is the proposed expansion. So the existing mine is on the south side. So there are various phases. There's phase A, there's phase E, which is primarily processing equipment, and phase B, which is on the north, and phase C, which is to the kind of in the center on the west, and then phase D, which is a hatched area on the west. So phase A consists of 21.5 acres, and that's phase A is entirely within the current permitted area. Phase E, the entire phase E, is 37.2 acres. Phase B is 25.2 acres, and phase C is 13.1 acres. So if I could just explain a little bit, the plan is that Kilgore would, as I've said, they've already disturbed phase A and a good part of phase E. With this approval, they would initially begin going into phase B, or continue with, expand into phase E, and then also start mining in phase B. But before mining in phase C, area B would be completely reclaimed, and the areas not needed for phase A would be reclaimed. Phase C is approved as part of this proposal, but at this time it is not bonded, so it would require a separate approval for them to go into that area. And also phase D is not approved, is not bonded or approved, And that, again, would also require a separate approval. And it would require a separate approval from the Bureau of Land Management as well. And this area is above the Bonneville shoreline, and there are some concerns about that. And so that's not being approved at this time, for Area
May I
D.
just ask Mr. Baker?
Yes.
On the map, is this oriented with north in the vertical direction?
Yes, it is. Sorry. Yes, north is up on this map. All of the maps I've shown, north has been up. That's correct.
I'll just ask one clarification question too. Phase E is primarily not a mining phase, but is the facilities. Is that correct?
Yes, that's right.
Okay, thanks.
The crusher and hot plant.
Okay, thank you.
Just a couple of other figures. We currently hold a reclamation surety in the amount of $268,396. The surety for phases A, B, and E is a total of $858,000, and phase C would be an additional $73,000. That's all I have.
Okay,
Glad to answer any questions if you have some.
I'll just ask sort of a summary question. So the main thing that this revision does is to just expand the area of the mine. It doesn't add any new processes or new facilities or anything of that nature. Is that right?
Yes, that's right.
Okay, thank you. Unless Mr. Baza has any questions for Mr. Baker, we'll continue with Ms. Abadi.
Please proceed.
Thank you, Meg. So some of the issues that I'll be addressing relate to air quality, groundwater, surface water, the reclamation plan, the public feedback we received. Oh, by the way, I'm sorry, I forgot to introduce myself. My name is April Abadi. I am with the division, and I am the lead technical reviewer on this project, as well as the inspector. Okay, let's start with air quality. So one of the things that we're required to review as part of this large mine permit expansion is the impacts to air quality, and that's how it's written in that rule. However, it's somewhat general, so the way that we handle that is that we look to what permits are required and what are appropriate through the Division of Air Quality. So two of the applicable permits that the Division of Air Quality requires, one is an approval order, and that's for the emissions on all of the equipment at the operation. And then the second is a fugitive dust control plan, which all operations within Utah County are required to have that are over 1/4 of an acre, because Utah County is considered a non-attainment area for PM10. It is considered something that all facilities are required to have. So Kilgore has both of these permits. I've checked recently as this past week with the Division of Air Quality to ensure that the company is in compliance with these permits. And I've been informed that they have. The DAQ has conducted several air quality inspections at the facility. They were down there in July, as well as just as recently as October, evaluating the dust control, and they've found them to be in compliance in both instances. Water quality. So similar to air quality, we are required to look at the impacts to groundwater and surface water in accordance with that rule. So when we looked at the groundwater protection, what we found is there are fuel oils, lubricants, and various chemicals that are stored on site, and that's just part of normal operations. All the hydrocarbon products are stored in containment as required by the company's Spill Prevention, Control, and Countermeasures Plan. That plan can be found in one of the appendices of our Notice of Intent. All fuel and lubricants have been found to be stored in either double-walled tanks that have leak detection or single-walled tanks within a secondary containment structure. Another item that the company has volunteered to do is provide an engineered clay liner beneath the recycled asphalt product stockpiles that are on site. So that's also one more means of protecting the groundwater below. And then lastly, the water right that the company has applied for was to divert up to 33.88 acre feet. That had just gone through approval with the state engineer. That decision just got issued at the end of October. So they will be installing a well on the property to provide water for general industrial operations as well as dust control. That rule also requires us to evaluate surface water and how that is being protected and contained. The mine is designed to not discharge, and there are several stormwater runoff controls that are in place. The mine is covered by what's called a multi-sector industrial stormwater permit that's issued by the Division of Water Quality. Let me show you a little bit about how that's configured. So again, we're looking at the site, and all those arrows represent the flow direction of stormwater. Currently, there is a stormwater retention pond at the very southeast corner of the property near the access road, right here. And as the mine gets built out on the northern end, there will be a new stormwater retention pond constructed, and that will be right here. So again, you'll see that all that water is designed to be contained. And one of the things that we do on our inspections is we're going to be looking for those things. We're going to be looking to make sure that stormwater is properly routed and that there's no blowouts of ditches and things are being contained on site. And then I'm going to touch a little bit more on the reclamation plan and the mine design. One of the major components of our permitting process and our rules is that all mines are required to have a pre-designed reclamation plan ahead of time. And with that comes a financial surety and where the company provides the funds to ensure that the property can be reclaimed. So that's been done in accordance to our rules there. The division did work pretty extensively with the company and the BLM to design a phased mining approach that Paul discussed so that the impact is minimized. We'll also be having not necessarily steeped benches that provide like a stepped look at reclamation. We're going to contour those benches and round them out again so that it won't be such a visual impact to the community upon reclamation. So within the past year and a half that we've been in this technical review, as well as within the comment period that just started after the tentative approval, we have received quite a significant amount of comments from the local residents. I wanted to point out here some of the comments that we got that have some merit that are outside of the scope of the division rules. However, we do feel that they are worth mentioning here. One of the things that was requested of us by mainly some residents of the South Mountain Community Voice was for aesthetics, and what was asked is if trees and shrubs could be planted around the perimeter of the mine disturbance area and have them be landscaped with an irrigation system, just to lessen the visual impact of the mine from the valley. They also requested additional protections of the Highline Canal area since there is a crossing over the road into the mine where the canal is at a somewhat vulnerable point. So their piping was requested, or a covering of some sort, just to provide some additional protections there. And then with truck traffic, unfortunately, that really isn't something within our rules. However, that would be something more with focus on the Utah County government. However, the citizens asked if counters could be installed there so that trucks coming in and out of the property could be counted, and perhaps that data could be provided to the county for some additional control measures if they wanted to implement them. So it is possible that these types of measures could still be negotiated with the operator, and if they do get incorporated into the mine plan, then at that point they would be enforceable as conditions of approval.
So, April, just a quick clarifier before we move on from that. So, if the operator satisfies the things that you covered in your earlier slide that are under our rules, they are entitled to a permit. Is that right?
Yes.
And these things would just be, I think you said it, but just as a clarifier, these would be voluntary things that they could do, but that could be enforceable if they were incorporated into our permit.
Correct.
Okay, thank you.
So in summary, air quality and water quality permits are issued by the DEQ. They are in place, and both of these agencies within the DEQ view the company as being in compliance. We did do quite a considerable amount of work in designing the mining and reclamation plan so that we did take into consideration the impact to the community. And lastly, the suggested actions by the community that would be considered outside the scope of our rules could certainly be incorporated into the mine plan. Thank you very much.
Okay, thank you. Just one final question. In your opinion, does the mine plan as tentatively approved minimize potential impacts to those things that are within the division's jurisdiction?
Yes.
Okay, thank you.
I may have some questions after we have made presentations. All right, Ms. Sainsbury, we'll turn over to you for 20 minutes.
Okay, thank you, Mr. Baza. I do appreciate being here today, and do appreciate you broadcasting this live and also recording it, because we do have several community members, because of the time and the location, that could not come here today. Like I mentioned, I am on the board of South Utah County Community Voice. Our chairperson is out of state right now and would also like to have the time to submit her input in the required time frame that you mentioned. So let's go ahead and voice some of our concerns and also some of the valid reasons why we feel that this permanent approval should be reconsidered. So we just first want to start out just with the Division of Oil, Gas, and Mining, the mission statement. Two things in there. That basically part of your mission statement encourages responsible reclamation and development, and also protects the human health and safety, the environment, in the interest of the state and its citizens. The first thing I want to talk about is responsible reclamation. And give you just a little history about West Mountain here. Currently on West Mountain, there are 7 approved mining operations on the mountain. And even though they're not approved, there's also evidence of 3 other areas of disturbed land. I'm assuming they're probably unapproved mining operations. But we have a saturation of mining operations on West Mountain. And if you will notice, there's a 7-mile radius to the east of the mountain. 6 of the mines on West Mountain access in this 7-mile radius. And so it directly impacts the community in a very negative way. Over the past 100 years, as the area has had their irrigation come in, it's been very favorable to agriculture. It's actually kind of a unique microclimate for the orchards out there, a very viable industry out there that cannot be located in other areas. The saturation of these gravel pits, as I mentioned, does have a negative impact on us, and to protect the health, safety, and welfare of Utah County residents, the County Commission and the Planning Commission are in the process of considering the possibility of rezoning the mountain. It's in the process right now. The county commissioners sent it to the Planning Commission to review and discuss. There's one thing that we need to bring out, and that is the consideration of the cumulative impacts on our community. So in the EPA, in the review of the NEPA documents, basically, and you've got your source there, it says the combined incremental effects of human activity referred to as cumulative impacts pose a serious threat to the environment. While they may be insignificant by themselves, cumulative impacts accumulate over time for one or more sources and can result in the degradation of important resources. So we did have attorney review the NOI, and they found no evidence in the NEPA, dated January 2016, that this cumulative impact study was done. And so we are asking that that be done because it definitely needs to be into consideration with our area. Okay, so concurrent reclamation. We have some large concerns in this area. The concurrent reclamation is mentioned several times throughout the NOI. On page 11, it states concurrent reclamation, where feasible, will take place within the permit area. And also on page 11, it states total areas of disturbance will be at a minimum. Page 20, total acres of disturbance, the same throughout the mine. And on page 26, it says no significant areas are available for concurrent reclamation. So as we look at that, they were discussing the different phases of the mine. Phase E, which is fully open right now, it actually has 13.7 acres that are in actual mining. And yes, the other acreage is used for their waste dumps, their stockpiles, their asphalt facility, all these other things. But 13.7 acres are active mining. We are being told that as they move into phase A and phase B, these phases will be open, mining will happen, and that the reclamation plan is that it doesn't need to be reclaimed until they actually go into phase C. So with this setup, that actually means 78% of the total mine will be open without any required reclamation, and we are very much concerned about that. We also pose the question, what is concurrent reclamation if the majority of the mine is open and you don't even begin reclamation? And we also pose the question of what is responsible reclamation? Is it responsible to have that much of the mine opened without beginning that reclamation? And is it unfeasible to say that they have to reclaim the 13.7 acres they are currently mining in phase E before they go on to phase A and B? Is it unfeasible to say that they cannot reclaim phase A before they go into phase B? So the feasibility on their part of saying that it is not feasible to reclaim all these other phases of their mine just doesn't add up to us. We would like to see more specifically why this cannot be done, and we would also like to know why that is considered responsible reclamation. So in the reclamation plan, it says that there will be spots, that there will be 300 to 400 foot high walls with a 45-degree slope. We have talked with the BLM, and in our conversation with them, in these areas, there's no redistribution of topsoil. How do you make it happen? It is so steep. You can't even get equipment on it. And the seeding, if it is to be done, almost needs to be done by helicopter. I was just in your hallway, saw some beautiful pictures of reclamation, saw your picture of your Star Point mine. Where they have their shear wall, you will notice it is basically a shear wall with no vegetation on there at all. So how are they going to be able to reclaim this shear wall? So the question I asked then is, so what is the viable uses of this shear wall? What can we use it with out there? without this responsible reclamation, it really won't happen. I also wanted to point out to you that the Utah County Land Use Ordinance 32-24, where it talks about exposed slopes to be less than the critical angle of repose, meaning the critical angle where dirt won't slough off and come down. Utah County angle is at 32 to 33%. That is what they consider a responsible reclamation, but we're looking at 45% here. I wanted you to also be aware the growth that's happening so you can kind of understand the dynamics of West Mountain. So this is bound in the utahfoundation.org. Future growth is coming out into Utah County. And the unincorporated area is actually getting the full impact of it, most of it, in the sense of the growth rate in the unincorporated area is at 501%. And at the rate that it's growing now, they're actually predicting that these figures of growth will be met by the year 2040. So our reclamation has to happen. West Mountain is already a residential community. And when this growth happens, are we going to have a mountain that is scarred by these shear walls? Are we going to have a mountain that has 78% of the expanded mine open? We have to have concurrent reclamation and responsible reclamation. We also want to talk a little bit about water and their water right. And I did want to point out the water right in that when it was submitted in the NOI, even the amended one in July, it was stated that they had the water right. That was actually not factual. They were just awarded that water right in October, and it was not a permanent approval at the time. We also need to clarify a little bit about this 33.88 acre feet. The 33.88 acre feet is the amount of the water right, but in the water right approval, they were actually given 15.31 acre feet annually. And the reason why, and it can go up to 33.88, but they have to show that this water is not consumptive. And so that is why the Water Division put it at 15.31 acre feet. And the possibility of it being 100% consumptive is pretty high. So you're looking almost half the water that they will actually be able to pull out of that well. So also in their NOI, they state that the water will not only be used for dust suppression, but is also going to be used to wash their aggregate and wash their trucks. So this water is going to be used for quite a few things. So we ask, how much water? Two questions. How much water is needed to adequately control the dust? These are pictures of the Kilgore mine on West Mountain. This is what we as residents face constantly. So let's talk about the fugitive dust a little bit. On page 23 of their NOI, that says the fugitive dust will be controlled by applying water to vehicle traffic areas and staging areas and unpaved routes. No dust control for area being mined. What about their stockpile area? What about the berms? Page 23, dust control will take place during working hours. No dust control during nights, weekends, holidays. Does the wind not blow during those times? Is there not dust during those times? We've had communication with the DAQ that told us that they actually require dust control at all times. Page 24 says they shall not apply, there's the rule with the DAQ that they don't have to do dust mitigation when wind exceeds 25 miles per hour. The vast majority of the days on the West Mountain, the wind is not above 17 to 20 miles per hour, so they will be responsible for dust mitigation most of those times. So the water supply that they have is insufficient. I have a couple of computations here. One is from engineer. He has a BS in civil engineering and an MS in geotechnical engineering. He has 27 years of experience, including specific experience in gravel mine operation. He's licensed in 5 states and 3 continents. So he did his figures on the availability of water of 33.88 acre feet. And the computation done for 33 acre feet means that they'll have 10,752,350 gallons, 1,350 gallons. So he estimated to control dust at the site, it would take an average of 15,000 to 20,000 gallons daily to meet the current mine acreage that is open right now. So if you were to then expand that mine, that figure would almost quadruple. Looking at that, just wanted to point out again, that's at 33 acre feet. Right now, the Division of Water Rights is allowing them to pull out 15.31 acre feet. The Benjamin Quarry does not have enough water. They can tell you they have water, but they do not. I have not seen any figures at all with their computations of their water need, and they need to be submitted. We need to know that this is going to happen. I also have, I also have received some documentation from another source in regards to the water supply. And this documentation is from Arizona, let's see, excuse me, I just need to find it. And they also have some computations. I've got it right here. And we can submit this to you. Okay, this is from the Maricopa County Air Quality Department in Phoenix, Arizona. And they have a guidance for application for dust control permit. And they give their guidelines, but they also did some water calculations. And in their water calculations, they basically estimate that it takes 30 gallons of water to suppress dust associated with the moving of 1 cubic yard of material. So that basically means that those 30 gallons for 1 cubic yard, Kilgore has stated that they will be taking 100 cubic yards out of their mine yearly. So based on the above, Kilgore will need at least, at minimum, 9.3 acre feet of water just to control their dust. That's looking at, right now, what happens when this mine expands. So, and then also, they're watering down their trucks, and then they're washing their aggregate. So they are sufficiently don't have the adequate water. We wanted to discuss a little bit on this air quality as well. Okay? It's just proven, documentation everywhere, that when you have gravel mine operations, asphalt, hot plants, you have emissions. You have fugitive dust. You can find it on the EPA. You can find it on OSHA. There's the documentation of the carcinogens in there, the adverse health effects that it has on people. You got to realize that when this Benjamin Quarry came in, they came in to an established area where residents live. The residents did not move in on the Kilgore mining operation. They came in to an established community. And once again, you've got your pictures. Does this follow the opacity rule that they're supposed to follow? There's some consistencies in the NOI that we have just seen. The NOI states that the Benjamin Quarry will not have any waste or overburdened dumps, tailing facilities, or treatment ponds. This is on page 19. Benjamin Quarry will not have any waste dump, tailings, ponds, or water storage ponds. The contradictions, the ambiguity that we see At Phase E in the tellings, it talks about disposal of 2.7 acres. Page 22, it talks about this facility has been designed to collect all services and stormwaters within the primary retention pond. We just need to make sure that these contradictions and ambiguities are revised and taken out of the NOI so we know exactly what is intended at this mine. Page 23, it says the major activities on the mine property that could impact groundwater, meaning blasting could be done, and blasting will be relatively minimal. But then on page 9, it says blasting may occur daily. Once again, an ambiguity and a contradiction. These things have got to be cleared up in the NOI. We've got to know what they are going to do in their operations. Chris, who is hired by Kilgore right now, expressed that the trucks leaving the mine will be washed when they come out, and we do appreciate that as a community. But we pose the question, where is this water being disposed of? I've seen that you have your ponds for the storm water, but where is the water going that these trucks are being washed with? What happens to it? Does it seep into the Highline Canal? Does it go down into the dirt? This has got to be accounted for. We need to know. We need to have the ponds that will take care of this water. They are washing recycled asphalt in aggregate to make their asphalt. In order to have this asphalt done, they have to wash it enough that their bonding will take place. Do they have a pond to contain this fine dust? If they don't, it is a huge deficiency, and there is possible contamination that will result from it, and it needs to be addressed.
Just so you know, you're at your 20 minutes. So
I'm sorry, I will hurry.
wrapping up soon.
Okay, other pertinent operations, and it was briefly discussed, and I'll just review these quickly because we know this doesn't directly impact you in the sense of your looking at roads specifically, but we wanted to point out that your decision to approve this mine does directly impact what happens in our community. And as of the Division of Oil, Gas, and Mining, that is part of your mission statement to protect the health and safety of the citizens of the state. So the roads, the width of the rural roads are insufficient. There's no shoulders on them at all. This picture here, this is the trucks lined up to go into the Kilgore mine, okay? The structural integrity of the rural roads, they are not holding up. They are small turning radiuses. The stop sign has been hit numerous times. I've seen trucks run the stop sign simply because of these radiuses. There's an excessively steep access road up to the pit that kind of goes into factoring of why the stop signs sometimes are run, and safety concerns, traffic on the road, school bus stops, people using the roads. You can see what we are facing and why we are concerned. Also, there are over 90
Okay,
documented rock art sites.
Sainsbury, I'm going to have you close right now.
Okay,
and
I will
move
stop.
on to Kilgore, but if you want to use your remaining 5 minutes on the next round,
You bet.
please do.
Okay, thank you.
Well, let's turn over to Kilgore and your discussion for 20 minutes and hear from you.
Thank you, Mr. Baza. I think I'll lead off here. Stuart Lamb with Kilgore Companies. I appreciate the citizens and their thorough assessment of our application and what we've been through the last 18 plus months. It's been a long process. The regulatory process is detailed, it's complex and expensive, and I feel confident their application satisfies the intent of the law. Some of the things, I just want to go back to, we would not be here today if we hadn't met the standards that Dogum has established as a sufficient application. And it was asked by April, do we address the environmental concerns as regulated by Dogum? The answer was yes. The application is sufficient. If it wasn't, we'd still be back at the drawing table. Second of all, there's a lot of concerns that have been raised, and we're sensitive to the concerns. We're sensitive to the neighborhood. We want to be a part of that neighborhood. I know we've been criticized for that, and we've got to work in the future to overcome some of these things. Some of the concerns some of those pictures that the citizens raised there is dust that you showed, some of that steam. And so there's a perspective here that there's an educational aspect of this that will improve over time. Whether small or whatever it is, there's a certain amount of emissions that is permitted under Utah state law. And we're regulated to comply with those. We're monitored, we're checked. We have numerous on-site visits, and the experts, if we're not in compliance, they bring us in compliance. So the air quality things, they're an act in progress, and we comply, and we keep continuing to comply as things change. There's a lot of discussion about water right, and there has been, and this argument against Kilgore's use of the waters goes both ways. One, we're using too much, and then the other aspect is we're not using enough. The reality is the state approved a diversion right of 33 acre-feet. They also approved a depletion right, and within 5 years we're obligated to submit how we use our water. And we will do that. We'll comply with the way we use our water. If we find that it's not sufficient, or if somehow we're not compliant with Utah law regarding water right usage and storage, we'll go get more water, and we'll do it according to state law. Or we'll work with, within our operations to make sure that we are meeting our depletion rights and our abilities to stay compliant with what we've been approved for. This pit was existing prior to Kilgore being there. There was an environmental assessment made in which time cumulative impacts was assessed as part of the decision record, the FONSI, and now the decision of no effect. Whether or not cumulative impacts occur is a decision by NEPA law as determined by the agency. We've complied with that, and it was a determining factor. It was reviewed, and the federal government, who is, they've determined that we've sufficiently addressed the issue of cumulative impacts. Let's see. Regarding the high wall, again, Dogham's interpretation of what is reclaimed is different than what it doesn't always mean plant growth. It means stable slopes. And we're under obligation to mine according to a stable slope standard, meaning reclamation is subject to geotechnical evaluation and review. And once we've satisfied the geotechnical aspects of and that the mine is safe and the wall is safe, and we've met standards that meet stability, then we can be signed off as far as reclaimed. Areas of this pit will be reseeded, areas that are hard rock and still meet a stabilized standard. We as far as washing a material, we don't wash. Joe was here. He can explain how he utilizes water on site, but it's applied directly through the processing of the plants, things like that. Greg, do you have anything else?
The slides that I can finish.
Okay. I just threw in a couple slides. The closest home, just kind of some background. Oh, I want to go back. This original pit was owned by a different operator. We came in, we took it over. The original EOA was for 160 acres. So whatever it was there was only a part of what was originally contemplated. So all we're doing is, when we say expansion, what we're doing is just moving the boundary that was originally anticipated. There was a question about the Bonneville shoreline, how it's not approved. Paul, you mentioned that this would be a separate approval, and it is correct. That came up with the landowner, which is the federal government. They said, look, we want you to be conscientious about mining above the Bonneville shoreline. They did not exclude it. It's still part of the permit. And And when we talked with, when we went through Dogham's review process, we intentionally left it in there because the landowner left it in there. Now, is there additional requirements for us to do? Yeah, additional engineering, some visual impacts, but, and some additional bonding through Dogham, yeah. But I don't want the public to think that that's not part of this mine operation, because it really is. It's just a temporary, it's held out temporarily until we figure out the additional engineering and everything, how it fits in. This is how the mine operation sits today. This, the crusher's up top, the hot plant in the middle, and the scales are on the bottom. Everything, with the exception of the crusher, is on private land. I just wanted to point that out. The plan also shows that that milled asphalt material would be brought in and fed to the plant. BLM was initially concerned about the impacts of milled material on public land, and we had a lot of discussion about, you know, whether they're safe or not. It came back they were safe. We've conceded in allowing or creating a geotechnical designed clay liner under where we store these things on federal land. It shows the adjoining property owners. The closest home, I think, is within 1,500 feet. We mine pits in other areas throughout the state with much closer homes, and have, you know, and these homes are very valuable in and around our pits. And that's just kind of the mine excavation plan, just showing how everything's out and the phasing. And then just the final reclamation, we kind of went through this. This kind of shows the distribution of the water system on the plant. It's on the system. It's on the production equipment. That's how you apply water in these systems. And this is how we trap and use emissions from our stacks and the asphalt plant. Anything else?
Can I just underline a few things? We are at a bit of a disadvantage as we are accused of various things because, take dust, for example. We receive regular visits from the Division of Air Quality. And whenever they come, we have been in compliance. We understand from the Division of Air Quality that oftentimes the division is called when we are not even in operation. And so that suggests that the concerns of at least some have probably something to do with just stopping our operations altogether and less to do with dust. We are here today saying that we will be in compliance. We have been in compliance and intend with this application to remain there. As it relates to water, we've been presented with some anecdotal slides today from the citizens, and what I can tell you is that we are in compliance with the requirements of this body, and we will continue to be in compliance. Otherwise, we could be shut down for not falling outside of the parameters of our application. As it relates to the reclamation, I think we've been very, very thorough in our application as to when certain elements of the mine will be reclaimed, and we intend to follow those. I think there is a built-in argument that our first desire is, after we get this approved, is to jump out of compliance. That isn't. We have every intention of living up to and walking up to each of the required items in our application. Let me speak specifically to dust. You've seen pictures at hearings before other bodies. We have seen pictures that have been brought up. I noted before that we've always been in compliance when the Division of Air Quality has come out to visit us. We have voluntarily implemented an additional dust control system. And that was one of the earlier slides that Stuart went through, as well as voluntarily adopted what's called a blue smoke system to reduce the exhaust and emissions from our equipment. This is above what is required by the Division of Air Quality, but it is an effort by Kilgore to hear the concerns that have been raised by our community and to attempt to address those. Anything else?
One other thing, April identified 3 things that, and Meg mentioned these, that would be above and beyond what Dogmas required us to do through the permit process. One was aesthetics, one was additional Highline Canal control safety measures, and then was the last one was truck traffic. That picture you saw of truck traffic was an anomaly. I hope that never happens again. But again, we have the ability, we keep track of our trucks and know exactly what's going in there and what's going out of there. The additional control measure around the Highline Canal, Lee Ware, our environmental manager, has been in coordination with the BOR and the Highline Canal in adopting some better protection measures, and I think we've got them on board. They're the landowners there, and so we're working with them to make that a little bit safer there. Aesthetics, that's something we'll just have to work with internally. I think we do want to do some things and can do some things, and Joe, and we'll communicate that through Dogum as we go forward. We've got some ideas that we can certainly do. I think, anything else, Joe, that you have in mind?
So we're happy to respond to questions, but we believe that our application is not only substantial and comprehensive, but it certainly follows the law, and we intend to continue to do that.
All right, I think does that conclude your presentation?
It does, yes, thank you.
I have some questions, and before we go into the final round, I think I'd like to have some of my questions answered. Mr. Baker or Ms. Abate, original ownership and the permitting, how long have we as a division permitted an activity at this site?
The original NOI was permitted in 2012 by a different operator. And then approximately 2 years ago, Kilgore took over and we transferred the permit to them.
In terms of a federal nexus on this, I understand that BLM is a primary landowner.
On the current footprint, it's private, but the expansion area is all BLM.
And was then there an NEPA conducted as part of that?
They had to go through approval through BLM prior to applying for our permit.
I suspect that was fairly recent.
It was, and then when we were going through the initial technical review on our permit, we did collaborate with the BLM on some issues, and BLM had comments and I had comments, and that's what resulted in the reclamation plan. So those are some factors that got adjusted.
When we initiated permitting back in 2012, was there already an operation on site?
Yes, there was.
How long ago did that occur? Years, decades?
Oh, you mean a prior operation?
Yes.
No, that was an initial operation that started with our permit. It wasn't grandfathered. Is that correct? Or was there just sand and gravel?
Actually, there was, I think it was considered a sand and gravel operation there to begin with, and then it was permitted under our program. So it was initially exempt, but then it was permitted.
Ms. Sainsbury, when you said that any activity moved into areas where residences were, how long ago did that occur?
Well, so in our area, the adjoining owners, when that sand and gravel operation came in, As community residents, we were basically told that the I-15 corridor project was going on and that there was a lot of gravel that needed to be happen, and that this pit was opening in on a temporary basis. And then once it was done, that it was going to close and they were going to reclaim it. So as a community, we all felt like we could do that. We could do our part, get the I-15 corridor, and that it would be reclaimed. And that's kind of where we all thought it was going to be. But it didn't unfold that way.
That was clear back in 2012 then.
Yeah, a little before that. I'd have to look at the timeline exactly, but it was close to that time. Yes.
So in your opinion, was the community engaged from day one, or did?
No, and that's kind of the one thing that is the difference. Like we have lived up in, West Mountain has been zoned mining and grazing since 1940. We have lived next to them, and you haven't seen us here before. But there is now a cumulative effect that is going on, and we are all noticing it, and that's why we're here today.
Mr. Baza.
Getting back to the division, I think Ms. Sainsbury said that there were 7 other operations on West Mountain. Are those all under division regulation?
Some are, some aren't. The Kilgore Quarry at the very south end is the Staker pit. Then there's an adjacent pit to Kilgore that's strictly sand and gravel, not under our regulations. And those others are also sand and gravel.
Mr. Baza,
Yes.
I have a comment to your question if it's appropriate.
Oh, sure, yeah.
So I think there's some important things here. The current mine is both public and private. The mine is on BLM land today, and it has been since initiation. The private, where the operations are private land. Was there NEPA performed before? Absolutely. There's an EA. There's been a couple cultural resource analyst evaluations up there. Absolutely. From the start, that's one of the reasons why we looked at this originally, and all the permits were solid. They were long-term permits, and they covered a big, 160-acre piece of ground. So what the residents saw was just the first phase. The last question, this is a sensitive one, because we have to be sensitive to the adjoining property owners, and we want to be. But there's an argument that zoning for mining was deliberate and intentional on that hillside, and it existed from the 1940s. So who moved in on whom here? And the reality is we have to learn how to cohabitate and work together. But at the time when these mines were permitted, our county forefathers knew at some point, with the growth that's happening, they wanted a competitive and a solid, good source of aggregate materials to support the industry and growth of the community. They've intentionally designated this area as such until now. I know they're considering a zone change, but the reality is these uses are expressly permitted by right to be there. Now, does that mean that we need to be more neighborly and get along? Yeah, we need to do things. But that's the reality of it.
Since you have the microphone, Mr. Lamb, let me ask you a couple of questions along that line of reasoning. First of all, you mentioned the truck traffic that the photo showed was an anomaly. What's the nature of that anomaly, and how frequently does that occur?
That occurred when there were some problems at the hot plant, and the trucks were stacked up as they tried to stage to get up the hill. We try to control that. We've been told by the county it's to not do that. So we try to do the best we can to avoid that. The county has an ordinance in place dealing with trucks, impacts to roads, but it doesn't have anything to do with volume. It has everything to do with, if you impact my road, you bond for the impact associated with that. There was some issues with some mining on the backside of West Mountain. They created that ordinance, and that's how they've selected to do that. we've had to come in and estimate through a traffic analysis how much truck traffic we're going to move out of there. We've bonded for that. A lot of the roads coming out of the pit are UDOT roads. So it's kind of a complicated, coordinated effort that has to happen there. And we're obligated to keep those roads in good condition, and UDOT works with us, and so is the county.
Since you brought it up, the concept of neighborly operations,
Yeah.
can I ask what kinds of things has Kilgore done for community outreach or?
We've received, there's been a lot of complaints that we haven't done enough. For example, a lot of complaints have said, you've come in here under the dark of night and you haven't let us know what you're going to do. Well, I didn't know what we were going to do until I get through this process. And now we know what we can do. Secondly, we've hired a consultant that has gone around and has interviewed residents. We've come up with a list of things that we can do, and we're about to go down the path of participating. We've already participated in local high schools, and we want to help, maybe participate in the local Benjamin Days. And, there's a list of things we're now working on because we've got, we've kind of know where we're coming from to be able to address the right problems.
Okay, my last question for you is on the facility side of it. You said that was on private land. Is that land that Kilgore owns, or have you leased it from somebody?
We have a long-term lease, exclusive rights to use the property.
Maybe then the last question, one more thing. I just wrote a note on here earlier. Does Kilgore attempt to do any water recycling to minimize your demands?
Minimize our demands. Is there a perception we're using we won't recycle water, right, Joe?
Not at this time.
Yeah. And there's, yeah.
Can I speak to that briefly?
Sure. And your name is, sir?
So my name is Joe Johnson. I'm one of the operations managers with Kilgore. Just as far as water usage and those kinds of things, obviously in a sand and gravel operation, the big use of the water will be in dust suppression and doing what we can to maintain compliance with Division of Air Quality. That's a bulk of that. So as far as recycling, we're not actively washing aggregate on site or anything where you typically have recycled water happening. You asked a little bit about neighborliness. I know there's always things we can do to improve from that aspect. I guess from an operational side, though, we have taken steps to try to be more neighborly. A couple of the slides that Stuart put up, one was our dust suppression system. We know that water's a valuable commodity there. And so we went out and invested in a system that can better use the water. I know this is probably an engineer's dream to look at the schematics on that, but what that does is that gives the ability at every drop point on the crusher that we have a spray point that is a high, they call it a high pressure, low volume water, so that it's the latest technology. It's the best that is used in America for dust suppression. We've installed that based on residents' concerns. The blue smoke system, which was on the following slide, was an additional measure to do all that we can above and beyond air quality requirements. That what we do is we take any, what the system is designed to do is take emissions from the asphalt silos and put those emissions back into the burner. So basically, it's almost like a afterburner type of effect where we can control those emissions and significantly reduce those. We feel like both of those projects have been extremely successful. So from the neighborliness side, there's always things we can improve on, but we have been actively engaged in trying to find ways to address some of the concerns that the residents do have a significant investment. Thank you.
Thank you. Would the parties be ready to move into the next round of the 5-minute lightning round? Okay, well then let's start with the division. Give you 5 minutes.
Okay, sure. Thank you. And I'll just start by saying that if any other questions come up for you, Mr. Baza, feel free to interrupt. I think it's more important to us that we address your questions than that, we try to respond to everything, because I just don't think we necessarily have time to respond to that, everything that's been raised. I'll just start with one point. I think the citizens were going to get to and didn't get there yet, with respect to the archaeological resources. The division did get some information that the BLM is back out on site, maybe even possibly today, reviewing again, seeing if there are any archaeological resources. And, if the BLM provides us with different information than what we've received thus far, that definitely would be taken into account and would have an effect on what is permitted. I think also Ms. Abadi wanted to make another point on rebuttal as well.
I wanted to mention regarding the reclamation plan and the 45-degree slopes. Basically, we know that a 1-to-1 slope is not really going to hold vegetation in most cases. It's just kind of the nature of things. But we are going to likely just have bedrock walls there. So we are not going to be able to do much seeding on that, but we shouldn't have a lot of dust just based on the rock nature of the walls.
So just to clarify, so what you're saying is that because it wouldn't be dirt anyway, no matter which slope it is, it wouldn't be available for reseeding.
Likely not.
Okay, thank you.
Is that 1-to-1 slope pretty common for high wall reclamation?
It's the maximum that's allowed in the rules, up to 45 degrees.
Okay, I think we've covered a lot of these points. I think on that 45-degree slope rule and the other mine that was mentioned, Miss Dean pointed out to me that that mine was reclaimed according to SMACRA, so that would not apply here. So that would be the explanation for the difference with this permit here versus a larger coal mine.
And Ms. Dean, I don't know if we'd introduced you before, but you want to do that?
I did introduce her, and I was speaking on her behalf because I'm told she doesn't appear on the screen, but I could happily switch seats or let
That's
her.
all right.
Okay.
I just didn't know if we'd identified Ms. Dean before.
Yes. Okay, thanks. Let's see. Okay. Just with respect to the amount of water, we do allow for water to be hauled in if the amount available via the water right was not enough. We don't require in our plan for them to do water calculations. That would be, again, something more that's in the DWQ purview. But if it was insufficient, the plan would allow for them to haul in additional water. Do you have anything? Okay. In the interest of time, I don't think we have anything else that wasn't covered, but again, happy to answer more questions if you have them.
So going to the citizens, let's go ahead and have your...
Final comments. Yes. The one thing that I feel like really hasn't been, I guess, addressed sufficiently is our question about the concurrent enrollment. Like, why do they have to do phase A and B before they start any reclamation? on Phase E, the 13.7 acres on Phase E, and why can they not reclaim Phase A before they go into Phase B? It's very evident that their water source is in question. The 15 acre feet versus the 33, and from our computations, they really don't have enough water. And yes, they can haul it in, but you're enlarging the imprint of this mine significantly. So if they are having trouble controlling fugitive dust now, how are they going to do it on 78% of the mine? And that really needs to be addressed. As far as reclamation of the shear wall, that is the maximum, that they can go to. But Utah County has it at 32 to 33%. And the question is why? It's because we're a residential area. We have people there, all in the county. Maybe a more judicious requirement would to have it at the 33% angle and not leave it at the 45% where communities are abating right up against it. In regards to the safety on the roads, well, I want to talk groundwater just briefly that I couldn't get to. We are concerned about our groundwater. They don't have a fine dust pond. They're saying they're not washing. They're washing for their asphalt, but how else do you make asphalt unless it's washed? That part I need to understand. But where are their containment ponds for these? It's just going to go down into our groundwater, and once our groundwater is contaminated, it's a done deal. These things need to be figured out. The open Highline Canal, significant. There was a truck that tipped this summer, and the oil and the gasoline just flowed on down where the canal was. So these things do need to be addressed. We appreciate Kilgore wanting to do those things to be a good neighbor. But in the past, we have found that their self-regulation has not happened. They've built silos out of compliance with Utah County code on the height. Just their water distribution and supply system, they are working on it. They got their water in 2016 out of the Highline Canal without any water rights. We feel like their dust control, their air quality control, all of these things, the liner, when they first brought their recycled asphalt, was just put straight on the ground. All these things have not happened until community complaints have come in. And we feel that there needs to be self-regulation. And if they haven't been able to self-regulate on a temporary permit, what makes us think they'll be able to do it on a permanent permit? We need to have more assurance. We need to have water computations of what they're going to use. And we need concurrent reclamation. Their plan to begin to reclaim when they enter Phase C, they can mine for years, 25 years plus, before they even begin to reclaim. That is not reclamation. That's just being able to operate a mine without doing reclamation. We would like all of these things addressed before any permanent decision is made on this expansion. Thank you.
Kilgore, let's go ahead and have your response.
Real quick, I negotiated a right to use that canal water by the Highline Canal. What they told me is they were putting M&I water out of a well in the canal, and we were using that water. We were never impacting any agricultural right or any agricultural use. Now, when it became politically sensitive, they said, find another source. And so that way, therefore, we went and purchased water, and we're going to drill a well. So we never took any water without permission. I have contracts and letters of approval and things like that. Built silos. We built 3 100-foot silos under approval by the Planning Commission. When the plant came in, there were 2 that were higher than what was allowed. County made mention of it. We put them down. Now we have the right to stand them again because we've gone through a legal process and shown that they can stand. The shear wall reclamation and the phasing. A lot of that reclamation will just be determined about how the mining proceeds. Is that fair, Joe? Yeah. It's not economic to go open a bunch a bunch of mine area and then have to come back and reclaim it. Typically, you mine, you reclaim, mine, reclaim. You know, that's kind of the scenario you would see in this situation. But the phasing plan, according to April, is limited to us, you know, where we can go and how much we can open, you know. Containment ponds and washing, we make asphalt without washing any of our rock products. Is that fair? There's no washing that goes on. There's no containment ponds that associated with washing. If we had a concrete plant up there, we probably would wash material. But then we would have to make sure we have the sufficient water rights and everything associated with that. I think that's about it.
Thank you. So, I don't think I have any questions right now, but I may come up with something in the next few days to the appropriate party. So hopefully as you checked in.
Could I ask you, Mr. Boston, Debbie here has a little more information than I do in regards to just the water rights and also the water out of the Strawberry Highline Canal. I do want to say that whatever was communicated, I have, you know, water rights on my land. I know I have the permits, and I know exactly what I need to have in order to use that water. And they did not have any permits at all
That's not
for
true.
that water. But Debbie does have a comment.
Thank you.
Okay, I'm going to give you 2 minutes since she didn't use all her time.
2 minutes, because I need 2 more minutes. But just in quick reply then, really quick. In Kilgore's first NOI. Oh, no. I hate this stuff. In Kilgore's first NOI, they state in that they have water available from either municipal or from Highline Canal. But to use water from the Highline Canal, they would have to get a water right change. Stated right in there. They did not get a water rights change. They went to Highline Canal, and Highline Canal leased them water, and they put them in Strawberry Project Canal, which is not approved to be used for industrial use. That was built for agricultural. They would have to have had a warrant contract number to convey water in that canal, which that warrant contract number ensures that the wear and tear, the operations and maintenance of that canal is paid for. They did not cover the operations and maintenance. That was on us because they did not go through the due process to do that.
So
Bass.
rather than have any kind of
Yeah, back and forth.
rebuttal or response on this, I think we've got to be concerned about use of water and appropriate use of water falls outside of much of what this division does. I mean, we can identify certain things with the state engineer in terms of what is available and who has the appropriate right to that. But we are normally not the agency that regulates or enforces that. So we'll just have to work through our own processes to try to identify if what was said has any relevance to our permit. We're going to go to the public comment period, and hopefully those of you who wanted to comment have signed in, or if you're going to comment, you'll sign in at the podium. Can I see just by a raise of hands how many folks are going to take advantage of that? That works. Yeah, I was hoping that we wouldn't have to extend this much past noon, and I think we can get it done in that time. But so whoever wants to go first, if I could ask you to step to the podium and take your 2 minutes and give us your thoughts. And please identify yourself for the court reporter as you speak.
Yeah, my name's Dave Reed. You made a comment as far as the shear wall goes, that it possibly wouldn't be dusty. I think that needs to be clarified. is it going to be dusty or isn't it going to be dusty? As far as the water goes, I'd like to know, not a public speaker, has there been a study on the aquifer, how much water there is? Because I think there was another comment here that said that it wasn't going to be regulated how much water you used. So how do we know that you're not going to go above and beyond? Because you can truck your water in. I can't because we're all on a well. So it's just a couple concerns. Thanks.
Hello, my name's Debbie Brozovich. I'm a resident in West Mountain. By failing to describe potential adverse impacts on the project on air quality and public health and safety, the NOI fails to comply with Rule 647-4109.4. Utah Administrative Code 647-4109.4 requires the applicant to describe the potential adverse impacts of its proposed mining operations, including impacts of mining on slope stability, erosion control, air quality, and public health and safety. Kilgore perfunctorily refers to the impacts of its planned operations on air quality, stating, "Dust will have a limited impact." They don't even recognize they have a problem. It won't be fixed. Fugitive dust generated from operations are mitigated and controlled with water. NOI, page 25. This inaccurate statement made without basis in the record is insufficient to meet the requirements of 109.4. Kilgore does not describe air quality impacts from its operation. This argument assumes you have submitted evidence of fugitive dust from current Kilgore operations and adversely impact air quality. Kilgore ignores the documented air quality impacts of its existing operation. The record confirms that these adverse impacts will continue and worsen with their proposed expansion. Therefore, Kilgore's description is not factually sound. As documented by nearby residents and farmers, existing operations at the Kilgore are having a significant adverse impact on air quality by creating dust clouds, exposing residents and property to dust, and by emitting dust that settles on farms and produce. It kills our orchards. There is nothing in the record to suggest that this adverse impact will cease. Indeed, because Kilgore proposes to expand the scope of its mining, which entails an increase in blasting, ground disturbance, disturbed land, movement of materials, and truck traffic. This adverse impact will increase severely. Presumably, Kilgore is complying with a fugitive dust rule and is otherwise mitigating the air quality impacts of its current operations. Yet nearby residents and local farmers have documented repeated and significant adverse air quality and public health and safety impacts from ongoing operations. There is nothing in the record to suggest that anything will change. Rather, because the material moved and disturbed acres increase, the evidence indicates that the air quality impairments will increase in severity. Therefore, Kilgore's statement in the NOI that dust will have limited impact is factually inaccurate. Contradicts record of evidence
Ma'am,
and lacks basis.
Ma'am,
in record.
you're over time now, so
Okay.
thank you very much.
Thank you.
Julie Blaney. I'm a resident, or I own property on West Mountain. We have a hay farm, and I think part of the picture of West Mountain that's missing here is that West Mountain is home to thousands of acres of cherry trees, apples, peaches, alfalfa fields, bees, and dairy farm. It's some of the most fertile, beautiful land in the state. There are also beautiful residences all over the mountains. Some homes are $1 million estates. These are beautiful homes that are being impacted by the mine, the dust, the pollution, the traffic. I'd like to read, I printed 3 copies of the study done for Maricopa Mining. In that study that you'll get a copy of, they tell us that to control dust on grading 10 acres of land requires 10,000 gallons of water per day. Kilgore is ambiguous when it describes the total amount of disturbed acres that will occur at its operations as the project progresses. The company does not commit itself to concurrent reclamation. In addition, the company does not address the extent to which existing mining activities will occur alongside the expanded activities. With that said, Phase A and B entail disturbances in the stockpiling on top of soils, adding up to 46.7 acres. So assume you've got 46.7 acres disturbed. You need 1,000 gallons per day per acre at 240 days a year. That's 11 million gallons, 11,208,000 gallons of water a year, which is 34.4 acre feet of water. Based on its lack of water to undertake sufficient dust control, Kilgore cannot claim, as it does, without citation or evidence, that dust at its facility will have limited effect on air quality, that dust will be mitigated and controlled, and that the project will not harm the public and welfare. To the extent that Kilgore plans to truck in water, the company fails to address significant and important undertaking in its plan of operations. So I want to give you this little statistic. Say that Kilgore is required to use 46 acre feet per year to control the dust with its expansion. Given that the company has the right to use 15 acre feet of water from the proposed wells, it would require trucks to bring in 10,400,000 gallons of water a year that would be trucked. This is 1,042 trips of trucks that are semis hauling 10,000 gallons of water each. This is unacceptable, and this impacts our community in a way that cannot even be estimated at this point. I know people on the paths of those trucks that are saying
Thank you very much. If you'd like to leave the report
that you'll have them.
Okay.
Okay.
Shauna Phelps, West Mountain resident. We currently have a U-pick farm out there, and we are expanding up the hill to the west and to the north. Would like to make a point. Kilgore has intimated that in 1942, since 1942, this has been a mining area. I would like to remind them that prior to that being changed into mining, it was agriculture. And remind them that in the past, we've had county commissioners that have been in the pockets of different organizations, and often that is why things get changed. So it's not necessarily because it was advantageous, or it could have been as a deal, you know, to help somebody else make money. We've had county commissioners that are in trouble in the past for doing things that they shouldn't have. Also, the pictures of the trucks and that being an anomaly, I don't believe that it is so much an anomaly as they indicate that it is. When there's jobs that need to be finished and fulfilled, you have a huge impact. You have a large number of trucks that all of a sudden descend on those areas and create a danger zone for other vehicles that are on the road and for children that are on the road waiting for buses. What was the other one that I can't remember? That's all I'm going to say.
I have that problem
Thank
all
you.
the time.
Also, I would like to see an accumulative effect since 2012. They supposedly have one up to 2012. I would like to see one from 2012 till now.
Thank you very much.
I'm Neil Lundell, and I'm a resident in Benjamin. My family moved to Benjamin from Sweden in the late 1800s. But anyway, I still run a small farming operation down there, and I'm the president of Duck Creek Irrigation. And over the years, I've noticed we're drying up. 9600 South, when I was a kid, had flowing wells all along that. The first time I noticed the one well went dry was during the drought in 2001. It come back in the winter. The next summer it went dry. Then it came back. We kind of went into a wet cycle. And this last drought that we went through starting in 2011, them wells have never came back. And so it upsets me to hear Kilgore say that if we run out of water, we're going to go get more water. Well, you know what? I'm on a well. I don't have culinary water down there. I have a culinary well. And if it goes dry, what am I going to do? When Del Monte plant was in across the road from Spanish Fork, IFA, they had deep wells. When they was pumping water heavy during harvest, Benjamin would go dry. So the residents of Benjamin would have to complain saying, hey, you're pulling too much water, we're drying up. Since then, the point of diversion has been moved to the mouth of Spanish Fork Canyon. Spanish Fork City now pumps deep wells and use it for their secondary irrigation for Spanish Fork City. The other concern I have, being the president of the irrigation company, is a few years ago, I got a letter from Water Rights Division, and they said that they was taking a share of our water and transferring it to a well down there in Benjamin. And in my reply back to them, this person did not have a legal water right. They didn't even own stock in our water company, but yet they was taking water from us. And I asked the state, I says, how can you take water from an irrigation company when they don't even have water stock in the company? Well, they never took our water stock, but my question is to the state, how are you keeping track of this water? If nobody's got to forfeit a stock certificate to that well, I could resell that stock numerous amounts of time and still have the water right. And as Benjamin is growing, they're sticking more straws in the cup, and we're losing our water. Thank you.
Thank you.
My name's Jenny. I'm a resident, been there for a very long time, and I've noticed, like this gentleman, that the water is drying up.
Could you pull that microphone down closer?
Sorry, I'm short. We've had an overflow well on our property for 40 years. It isn't overflow anymore. I don't know where you people think you're going to get your water, because the residents own those wells. They own the water below that ground, below those wells. You're going to come along, you're going to drop your wells, and you're going to dry up our community, just like Spanish Fork City dried up Benjamin. It is not right. You should have a conscience about how this is going to affect these families that live in these homes that are this community that you are impacting. I've seen the dust blow across West Mountain and cover homes and properties that you guys don't even have a clue what's going on. There's children that live on that mountain that have asthma. You don't think that dust doesn't affect those kids? The trucks that are running up and down those roads. What about the animals? What about the livestock? What if there's something out, those trucks are going to hit those animals? What about the bus stop that those trucks are running? Those stop signs. There's a bus stop where those trucks turn and go up to Kilgore. That's a bus stop where children, anyway. The orchards, you've heard about the orchards. The roads, they're being destroyed. The ruts, you can't believe the ruts. What happens when it snows? And that great big steep incline that comes down off that mine, are those trucks going to go through those farmers' fences? Have you considered that? Those roads aren't even established for the amount of traffic on those semis that are going up and down those roads. That road is this wide. Those trucks are this wide when you've got two going back and forth. If it snows, and it's going to snow, it's going to be slick. Have you considered that? This was zoned for mining. It is agriculture. These homes are families. There's hay, and there's orchards, and this is not a mining agriculture community. You came into a community. You didn't build a mine and then the community was built around you. You came into an established community. You need to understand this community, these families. These are people that you're affecting. And it's not right. You should have conscience about that. Thank you.
Hello, my name is Nita Birch. Hope you'll excuse my voice. I seem to have, this last month, have like permanent laryngitis, and it gets worse at night. My family is one of those that have health problems, and my husband has recently has somehow unexplained dangerously high blood pressure now. And we moved to West Mountain 18 years ago, and for 20 years we were in Orem under the shadow of Geneva Still, and it made a big difference in our health. And being in West Mountain for 18 years, it was wonderful until recently with our health. But West Mountain is a historic mountain. Not only is West Mountain the only single standing mountain in Utah, known as the Island Rock, it is Utah's 74th prominent peak. The north side of West Mountain, exactly where Kilgore is located, was an historic Fremont Indian archaeological site. Kilgore should be taken to court for the destruction of such a historic area. As for the water in this area, the aquifers are not only vulnerable during a drought, water is a constant concern and has been for years. Many of my neighbors whose families have been in West Mountain for over 100 years, their wells have dried up due to the development above their land. The water crisis the residents of southern Utah County presently have is only a drop in the bucket. This year alone, there have been 6 public hearings to protest Kilgore and their lack of control in their dust, or it's not just dust, and other infractions. The Utah County Commissioners are currently in process of deciding if West Mountain should be rezoned from a grazing mining to a G1 grazing zone. Kilgore is planning to be a large mine. With the high winds that West Mountain has on a regular basis, even with the tremendous amount of water Kilgore has applied for, there still will not be enough to control their dust. And it's not just dust. At the gravel pit, there's all kinds of chemicals, especially there's call it crystalline silica is common from processing gravel, and it's a known carcinogen. And for children, it could cause especially vulnerable for infants and for the elderly and anyone who has breathing problems. And please follow your motto, that of protecting human health, safety, and interests of the state and its citizens, and deny Kilgore expansion on West Mountain. Thank you.
I'm not seeing anyone rushing to the microphone right now. Let's call an end to our public comment period on this. I'm going to consult with council for just a minute. And
here's the mine right here. Like here's the road that goes up there. This is the mine, right? That's all this. That 33 acre feet sits in a well right here, right by the Southam well. I have the right to do that. Yeah. That was done years ago. Years ago. So this.
We're in the process of
Right here. Like here's the Southam house right here, or the Southam house. Right here. I could go there today. I could have gone there today without any change application. Chris, that 33 acre feet right there.
Oh, yeah. Like it was right there in the application.
When that transfer took place, it wasn't us. It was years ago. Years ago, the state. We need to find value in that water.
Why do you need the approval? Just because you're moving it from here to here?
Yeah, we reserve the right to move it, but you can't exceed the one.
And that counters our rule.
I know, but you're going to start out with one.
But I actually think that does not apply to this type of an operation. But we need to look at it.
I'm just saying that statute's out there.
Yeah, yeah.
Thank you very much. First of all, I want to thank everyone who attended today. I appreciate your interest and involvement. Mining responsibly. I'm sure you the division has that same interest. Our mining is, excuse me. Most people say that they can't hear me when I speak, especially my wife. So let me start over. Again, I want to thank those who have attended. I think it's important that we hear these comments. I think it's important that Kilgore hears these comments. There's clearly a lot of passion out there to make sure that things are done right here in the state of Utah. And I have that same concern in directing the division, and I want to make sure they're doing the job right. I indicated to begin with that we were going to hold the comment period open for another 5 days till the close of business on the 14th. The rules indicate that after that, I'm to issue an order in this regard within a reasonable length of time. Obviously, we want to take the comments that have been received today, have the division staff analyze those, determine what falls within our authority and jurisdiction, what can be done in terms of the NOI, in terms of modification. But again, I will issue an order on this after the division has provided me with their analysis of the comments, and then issue an order in a reasonable length of time. I think it was good for you to be here. I think it was good for division staff to hear your concerns and comments. I think it's important that Kilgore hear these concerns and comments. We want to ensure that mining and reclamation in the state is done responsibly. Along those lines, if the operators can do anything to help ensure that that happens, we would appreciate that. So, have I missed anything, Emma? Well, with that, I'm going to call the hearing today closed. And appreciate all of you coming, and I provided the mailing address for paper comments and an email address earlier. Does anybody still want me to repeat that at this point? Okay. So the mailing address, hold on. Mailing address is to the Division of Oil, Gas, and Mining, 1594 West North Temple, Suite 1210 in Salt Lake City, zip code 84116. Or you can email an electronic comment to ogmminerals@utah.gov. OGM as in oil, gas, and mining, minerals, all one word. So again, with that, I will call a close to this informal hearing, and thank you very much for attending.